the law, it is generally taken to court. Whether it be something as small as a speeding ticket or something as big as murder, everything is handled within the courts. This year, I am taking U.S. government, and it has taught me many interesting things about the U.S. government and our Constitution. Recently, we have been discussing the amendments in our judicial system. One thing I've learned is with the help of the 6th and the 8th Amendments, citizens have the right to a speedy trial with the benefit of no cruel or unusual punishment. Today, I would like to enlighten you on how America's federal court system works. It all starts with the district courts, then moves to the circuit courts, and ends with the Supreme Court. Jeremy Baker from Research Starter Sociology states, while the overwhelming majority of legal cases cycle through the judicial system by settling out of court, courts remain crucial to the orderly operation of American society. It all begins with the district courts. There are 94 district courts with over 600 judges and handling over 80% of federal cases. The Handy American Government Answer Book states there is one court from each state, including Washington, D.C., Puerto Rico, the Virgin Islands, Guam, and the Northern Mariana Islands. The Handy American Government Book also states that Congress sets limits on which cases the district courts receive. These limits are very vague, and they end up getting a lot more than they're expected. This can be from anything from a civil case to a criminal case, with something as small as a child custody battle or personal injury, or something as big as murder or fraud. But not everyone can get to the district court. Usually, you're only allowed to go to the district court if you were not able to come to an agreement or reach a settlement within your local county court, or it was an unresolved misdemeanor. If you cannot appeal to the district court and it is not solved, then you can have the right to appeal to the circuit courts. The next level is the circuit courts. The 94 district courts are divided into the 12 circuit courts, which have 6 to 28 judges. The circuit court hears appeals from district courts and federal administrative agencies such as the FDA, SBA, Department of Justice, and many more. Jonathan Cohen from Inside the Appellate Courts explains to us how this process works. First, it starts out with each individual judge within the circuit court deciding on their goals for their case, whether it be a legal case, a policy case, or a social case. Next, a panel of judges is created based on their goals. After that, whenever the panel goes to court, they then go back to their chambers and discuss with their personal clerks on what they would like to decide for the case. An example of a case that went through the circuit court is the United States v. Hardin. Grant Ford from the St. Louis Law Journal states that United States v. Hardin was a case in which a defendant from the Southern District of Illinois consented to having a magistrate judge accept his guilty plea. After the judge accepted it, he realized that the defendant realized that his judge lacked statutory authority, which invalidated his plea. The defendant appealed to the 7th Circuit Court, and the 7th Circuit Court agreed. This now allowed prisoners to collaterally attack their sentences. Although it is very rare that a prisoner is successful with this, they are being heard and progress is being made. If justice is not served at the circuit court or other laws have been broken, you have the right to appeal to the Supreme Court. The Supreme Court is the third and highest court level to appeal to. It is rare that cases actually get heard within the Supreme Court. The Supreme Court receives over 8,000 cases a year, and only 80 of those cases are seen, making a 1% acceptance rate into the Supreme Court. To even get the chance to be heard, you have to write a petition for a writ cert, which is the facts of the case, not how the case should be solved. Those points are mentioned later on in the petition. Next, The Supreme Court justices decide whether this case is a threat to national importance. The federal law, the district courts invalidate federal law, or it can resolve split decision. An example of a case that went through the Supreme Court is Hazelwood versus Kohlmeyer. In this case, 2 students from Hazelwood High School wrote articles about abortion and divorce in their school newspaper. After the principal had read it, he had removed the articles from it, and they accused him of infringing upon their First Amendment right. Back then, the Supreme Court wasn't as hard to get into as it is now, so they appealed to the Supreme Court. They were very confident in their standpoints, and they were shot down immediately whenever the Supreme Court disagreed with them. The Supreme Court claimed that their First Amendment right was not infringed upon, so they had denied their appeal. The Supreme Court then stated that school administration is allowed to post and remove stuff if it goes against school values or rules. Just because the Supreme Court is the highest court and can ultimately decide anything, they do not have all the power in the world. There is a fair share of balance of powers, and Congress can overrule any verdict or impeach justices. The American federal court system starts out with the district court, then moves to circuit courts, and finishes with the Supreme Courts. With the help of the Sixth and Eighth Amendments, citizens are given the constitutional right to appeal to anything that they see due. After all, America is one country, one nation under God, with liberty and justice for all.
Crazy.
That was a terrible